Note cards, tort law, part 1. What is a social guest? A social guest is a person who goes on another's property for companionship, diversion, entertainment, or the owner's interests. Comparatively, what is an invitee? An invitee is a person who goes onto the owner's property for the owner's benefit. Licensee. Licensee is a social guest who is one who enters the premises of the owner by permission, but for the licensee's own purposes. The level of care that is required of the owner for a social guest, which is a person who goes onto another's property for companionship, diversion, or entertainment, which is in the owner's interests, is due care from the owner, but for the most part, the social guest takes the premises as it is found, versus the invitee, who is a person who goes onto the owner's property for the owner's benefit, meaning a shopper goes to Nordstrom's, and the owner has a duty to protect its invitee. For a licensee, this is a social guest who enters the premises of the owner by permission, but for the licensee's own purposes, like to sell him cookies. Mostly these are business people, and the owner must only warn the licensee of dangers. What is negligence per se? In negligence per se, the plaintiff is allowed to take a shortcut to prove what the reasonable person would have done by reference to a statute, and the judge determines if the statute applies. Case law determines what effect the unexcused violation of the statute will have, and in all jurisdictions, the jury still must determine if the statute was violated, if the violation caused the injury, and what the damages are. If the plaintiff fails to persuade the court the statute applies, the plaintiff can still prove negligence through use of the reasonable person standard. These 1, 2, 3, 4, 5 points under negligence per se are how it is distinguishable from res ipsa loquitur. Before going into what is res ipsa loquitur, let me read negligence per se from most likely the restatement of torts, which is the existence of a duty owed to the plaintiff and breach thereof may be established by proof that the defendant violated an applicable statute. So, if the driver of the vehicle left his keys in the car, no. Negligence per se. Defendant broke the law, and it's easier to show that he breached a duty if he broke the law. But there are some caveats. The law needs to protect the class of persons that the plaintiff belongs to, and it needs to protect them from the type of injury that he sustained. So I know of at least those two elements off the top of my head, but I didn't write them here. Res ipsa loquitur is another tool that the plaintiff uses to try to prove and to have evidence necessary to prove his case. In res ipsa loquitur, from hopefully the restatement, as it was provided in the Barbary outline, is defined as the thing speaks for itself in Latin, and is defined as facts presented by the plaintiff are strong enough to establish an inference of negligence, that the case cannot be dismissed for a lack of evidence because the facts so strongly indicate that the plaintiff's injuries resulted from defendant's act so as to establish that a duty was owed and breached. Defendant is burdened with the duty then to provide evidence in the contrary. Now, there are several points provided by the professor distinguishing the doctrine of res ipsa loquitur from negligence per se, starting with this is a doctrine that allows the plaintiff to get past summary judgment or a directed verdict and to the jury. And this is where the plaintiff has no direct or circumstantial evidence of negligence. That's the origin of this rule. And the judge determines whether res ipsa loquitur applies to the circumstances of the case, A, B, and C, under the judge determining whether res ipsa loquitur applies to the circumstances of the case. A, the instrumentality of the harm. These are your elements. The instrumentality of the harm was in the exclusive control of the defendant, and the accident does not ordinarily occur in the absence of negligence, and plus, in a few jurisdictions, the plaintiff's conduct did not cause the accident, or so you can't find any contributory negligence on the plaintiff, or the defendant has superior access to information about what happened. So that's just in a few jurisdictions is where that comes into play. So the judge here determines, and then in medical malpractice cases, the plaintiff must have an expert witness to establish whether some injury would not have occurred in the absence of negligence. And the case law in the jurisdiction determines the effect of res ipsa loquitur. A, B, and C under this case law in the jurisdiction determining the effect of res ipsa loquitur. A, permissible inference of negligence. B, rebutable presumption of negligence. Or C, shifting of the burden of proof to the defendant. So that's what will happen once the judge decides that res ipsa loquitur applies. In some jurisdictions, this will lead to a permissible inference of negligence, meaning that the instructions to the jury can allow them to make an inference based on just evidence not being available, but the evidence being that in all likelihood the signs point to the defendant, who was, as we know, in charge, exclusive control of the instrumentality of the harm, and that the accident does not ordinarily occur in the absence of negligence. So alternatively, in some jurisdictions, proving res ipsa loquitur to the judge allows is a rebutable presumption of negligence. Not quite. I think that means that some jurisdictions allow a rebutable presumption of... Right. So res ipsa loquitur would give the plaintiff right to present negligence to the jury, to give them permissible inference of negligence, and then the defendant, the burden of proof would shift to the defendant, and he would have to exercise a rebutable presumption. He would have a rebutable presumption to negate the negligence established by res ipsa loquitur. And the second point here under res ipsa loquitur is the jury must still determine whether there was negligence, causation, and damages. And if the plaintiff fails to persuade the court that the doctrine applies, the plaintiff usually ends up with summary judgment or a directed verdict against him or her because he has no direct or circumstantial evidence of negligent conduct. So the times in which you use res ipsa loquitur would be when you just don't know what happened. You were knocked out by a barrel of flour that fell from the defendant's house onto you, or like a piano, and you don't know how the piano fell on you, but in all likelihood, if the piano belonged to the defendant and it fell from his house, then you're probably going to argue under the res ipsa loquitur doctrine that you deserve for your case to be heard by a jury, even though you can't say that it was the dog, the defendant's dog, or the defendant's third-party service provider. So, again, let's read what the rule of law is for negligence per se. The existence of a duty owed to the defendant and the breach thereof may be established by proof that the defendant violated an applicable statute. And for this to be the case, the statute has to protect the class of persons that the plaintiff belongs to, and in the way in which the statute is meant to protect them. So res ipsa loquitur, according to this Latin translation, the thing speaks for itself. Facts presented by the plaintiff are strong enough to establish an inference of negligence that the case cannot be dismissed for a lack of evidence, because the facts so strongly indicate that plaintiff's injuries resulted from defendant's acts, so as to establish that the duty was owed by the defendant to the plaintiff and breached, and the defendant then, in many jurisdictions, is burdened with the duty to evidence the contrary. So we already read about social guests, licensees, invitees. Moving on to comparative negligence and contributory negligence. So the majority rule for comparative negligence, which came after contributory negligence, so I might as well read them in order in which they presented themselves in history. Establishing prima facie negligence on the part of the plaintiff that contributed to the plaintiff's injury can be a defense to negligence, not except in an intentional tort, because intentional torts do not fit into negligence. And a violation of a statute or plaintiff doesn't help himself unless the standard of care is lower because the plaintiff is acting in emergency. So those are just some examples from case law. But contributory negligence in England, where it originated, was a complete defense for the defendant's actions. So if the plaintiff had, say, what I'm alluding to here is the plaintiff was jaywalking when he got hit, that would be a complete defense. If negligence per se were established, that would be a complete defense for the defendant who had struck him while he was jaywalking, because the negligent act was shared by himself and also the plaintiff. So it would only allow a reviewable presumption that, hey, maybe that person was jaywalking because there was a fire on the other side of the road and there was an obstruction on the other. So that would provide a rebuttable presumption of the negligence per se on the plaintiffs, as party of the plaintiff. So to read that again now from that lens, establishing prima facie negligence on the part of the plaintiff that contributed to his own injury can be a defense to negligence. But what we know from case law is that this is a defense to negligence, not intentional torts. And we also know how negligence per se plays into it. And we also know that the plaintiff who doesn't help himself is another instance of contributory negligence. So if I have been impaled, if I've lost a limb because of the defendant's negligence and I refuse to have it reattached in a hospital, then I have made a negligent decision that now excuses the plaintiff from his negligence. And lastly, unless the standard of care is lower because the plaintiff is acting in an emergency. So if the plaintiff has a decision between two wrongs, right? A thief has jumped into his taxi cab and told him to drive as fast as he can away from the police. Then the plaintiff, with a gun to his head, then the plaintiff acting in emergency doesn't necessarily, if he jumps out of the car instead of driving and his car ends up striking a baby in a wagon, he's not necessarily, or the defendant isn't necessarily excused from putting the plaintiff in that position. So that's an example of contributory negligence being offset by extenuating circumstances. What has developed in America since contributory negligence came about is comparative negligence. You almost never see contributory negligence anymore, completely excusing the defendant from all liability. Now you'll see that to the extent that the plaintiff was negligent, his awarded the verdict will be reduced by his own negligence. And the majority rule here is that contributory negligent plaintiffs may be permitted to recover a percentage of damages under the comparative negligence system, where the jury weighs the plaintiff's negligence against that of the defendant and reduces the plaintiff's damages accordingly. Now, there's a couple different rules. There's pure Comparative negligence would say that if the plaintiff is 10% responsible, he can recover. Let's say the plaintiff is 90% responsible for his accident. He can recover 100% minus his own fault, which is 90%. So he will only recover 10% from of his damages from the defendant in a pure comparative negligence system. There are two other systems. One which allows recovery if the plaintiff is not more responsible than the defendant. And there's another version that's very similar to that, which would say 50 and above. So if the plaintiff's negligence is either 50% responsible or above, he would not be able to recover. So I'm going to look up those rules and put them in the next recording about pure contributory negligence, because I know I don't have a note card on them. Okay, so negligence, we got ahead of ourselves. Negligence is a person acts negligently if the person does not exercise reasonable care under all circumstances. Primary factors to consider in ascertaining whether the person's conduct lacks reasonable care are the foreseeable likelihood that the person's conduct will result in harm, or the foreseeable severity of any harm that may ensue, and the burden of precautions to eliminate or reduce the risk of harm. So, so negligence is when a person fails to exercise reasonable care under all circumstances. And the primary factors to consider whether the person's conduct lacks reasonable care is the foreseeable likelihood that the conduct will result in harm, and the foreseeable severity of any harm that may ensue, and the burden of precautions to eliminate or reduce the risk of harm. So this is probably where some theories could come into play, like the risk utility balancing analysis, and another theory to prove that the burden of taking precautions did not outweigh the likelihood of the injury or the magnitude, meaning the cost of the injury. The risk utility analysis usually, but it goes by another term, so we're going to get that and read that in the next section. To continue, there's a theory of conversion here. An intentionally exercise of dominion or control over chattel which so seriously interferes with the right of another to control it that the actor may justly be required to pay the other the full value of the chattel. That's your theory of conversion. Put another way, that is an intentional exercise of dominion or control over a chattel which so seriously interferes with the right of another to control it that the actor may be justly required to pay the other the full value of the chattel. Compare conversion to trespass to chattel. Start there. With a short one. A trespass to a chattel may be committed by intentionally dispossessing another of the chattel, or B, by using or intermeddling with a chattel in the possession of another. And another way to put a trespass to chattels, this does come from the restatement, is one who, without consensual or other privilege to do so, uses or otherwise intentionally intermeddles with the chattel which is in possession of another, is liable for a trespass to such possession if A, B, and C occurs. A, the chattel is impaired as to its condition, quality, or value. B, the possessor is dispossessed of or deprived of the use of the chattel for a substantial time. Or C, bodily harm is thereby caused to the possessor or to some person or thing in which the possessor has legally protected interest. So when you're talking trespass and you're talking conversion, as opposed to negligence, we're talking about intentional torts. While I'm on the topic of negligence, which is not an intentional tort, I found another note card which reads, the duty is the standard of care which is reasonable under the circumstances. Okay. Negligence has 4 parts, which I probably didn't write on the other card because it's so obvious that it has 4 parts. No one who studies law will ever forget those 4 parts. Starts with a duty to provide a standard of care, reasonable under circumstances, and then a breach thereof of that duty, causation, meaning that that breach of that duty caused damages to the plaintiff. Those are your elements of negligence. Going back to intentional torts, you have assault. Starting with assault. An act by the defendant creating a reasonable apprehension in the plaintiff of immediate harmful or offensive contact to the plaintiff's person, and 2, the intent on the part of the defendant to bring about in the plaintiff apprehension of immediate harmful or offensive contact with the plaintiff's person, and thirdly, causation. Those are the elements of assault. I hate that definition because I didn't explain what causation meant. So, as opposed to, you could say battery. Oops. We have another assault definition here. The defendant intends to place the plaintiff in apprehension of imminent offensive or harmful content. This requires the elements of intent, that the plaintiff was in apprehension or negative expectation of a third of imminent, which means that it's present. The risk is present of 4 offensive or harmful conduct. The closest intentional tort to assault is one which we refer to as battery, which is an act by the defendant which brings about harmful or offensive contact to the plaintiff's person and to intent on the part of the defendant to bring about harmful or offensive contact to the plaintiff's person. And 3, causation. And 4, intent. This is a side note. Intent can be proven by a defendant having substantial certainty that his conduct could bring about harmful or offensive contact to the plaintiff's person, and also nevertheless still proceeding in a volitional act that had a substantial certainty to bring about harmful or offensive contact to the plaintiff's person. So the elements, as the professor has us memorize, is that in battery there has to be intentional harm, the intent to touch, the intent to harm, and an actual touching and actual harm. Those are the elements of battery. To read battery from the restatement, your definition is: an actor is subject to liability to another for battery. A, if the person of another or a third person or an imminent apprehension of such a contact. Okay. So, an actor is subject to liability to another for battery if a person of the other or a third person or an imminent apprehension of such a contact. And B, an offensive contact with the person of the other directly or indirectly results. C, an act which is not done with the intention stated in subsection 1A does not make the actor liable to the other for a mere offensive contact with another's person, although the act involves an unreasonable risk of inflicting it, and therefore would be negligent or reckless if the risk threatened bodily harm. Beautiful definition. Just so helpful. Okay, so let's just return to. No, let's proceed. Let us proceed. A couple notes for next time. No, let's return to res ipsa loquitur. The thing speaks for itself. Whether there is factual predicate sufficient to support an inference that the injury was caused by the failure of the party in control to exercise due care. It's an interesting way to put it. But this doctrine's been around a while, so that's why we've got lots of different ways to put it. Every judge puts it differently. Res ipsa loquitur is a doctrine that the plaintiff can use whether there is factual predicate sufficient to support an inference that the injury was caused by the failure of the party in control of the instrumentality of the injury to exercise care. Lovely. Okay, I don't really like that definition either. Let's go to some other intentional torts, like false imprisonment. In short, is 1, 2, and 3. 1, an act or omission to act on the part of the defendant that confines or restrains the plaintiff to a bounded area. 2, intent on the part of the defendant to confine or restrain, so that's the intent. And 3rd is the causation, meaning that that person didn't just wind up restrained it was the defendant. The defendant caused that person to be in a position where he was confined or restrained to a bounded area. In another definition, we have unlawful restraint through force or threat of force against one's will that confines someone to a bounded area for some time without justification. I love that definition. And here's some thoughts to consider, factors to consider from case law, is that quarantine is not unlawful. So if everyone has to stay on an airplane because somebody brought in like a bug or something, then that quarantine is totally lawful, and you cannot call it false imprisonment even if you're ice. Consciousness of confinement is the minority rule. So some jurisdictions require that the plaintiff knows that he's confined. So if he wakes up, if he's unconscious, wakes up in bed, never knowing that, I don't know, while he was unconscious, he was in like police custody or something, and then, I don't know, magically transported him back to bed, then he doesn't have a cause of action against the police for false imprisonment or whatever. Okay, no, maybe this. Let's not call it the police. Let's call it like his mom or his crazy girlfriend locks him in, and he doesn't know because he's sleeping. Wakes up and she's decided she's not locking him in anymore, and he leaves. He doesn't have an action of false imprisonment against his crazy girlfriend. Another factor is moral persuasion is not force. So if somebody says you better not leave or else God is going to XYZ, then that's moral persuasion. Okay, the better example is when a person is being held by a retailer to prove that he or she did not steal from the retailer. This isn't by force, this is by moral persuasion that the plaintiff is being kept to clear his honor and name, and not because he has a gun to his head. Now, force includes, for a note about force, includes physical impediments, which includes like a barrier, which for example can be a body of water or a bodyguard. And we're using Whitaker as a example. That's a case where the defendant said that he would take his friend's wife home and by boat to America, and when she gets there, he won't let her have a rowboat to row onto America's soil. So, because she was under the impression that he would, based on the way that he explained him taking her there, and the rowboats were in his possession, and she thought she would get use of them, then him not providing them to her gives rise to a cause of action for false imprisonment. I do not know any better way of explaining that, and we will figure that out eventually. An act or omission to act on the part of the defendant that confines or restrains the plaintiff to a bounded area. So this can be an omission. Perhaps police officer A knows that police officer B did not, well, perhaps police officer A witnessed a event that led to police officer B arresting the plaintiff, and B has a, good faith, I don't know if I have malicious arrest, false arrest in here. False arrest arises when one is taken into custody by a person who does not have the proper legal authority. This can be an legal authority. A complete defense to false arrest is when an officer uses a warrant and has a reasonable belief that the plaintiff commit the specific offense. So if Officer A doesn't think that it was actually the plaintiff and thinks it was like the plaintiff's like friend and doesn't tell Officer B, and Officer B takes in him, then that's an omission to act on the part of the defendant that confines or restrains the plaintiff to a bounded area. Although it probably would fall under false arrest based on the defendant being a public official, a peace officer. So, do we have yet one more definition? Direct restraint of one person of the physical liberty of another without legal justification. This requires the consciousness of confinement in some jurisdictions. So, most of our we've gotten through many of our intentional torts. There's still a couple here on trespassing. So, trespassing is every unauthorized entry to another's land, and it requires the intent to enter the land of someone else, and actual damages are not required for a trespass to land. Another way to put this from case with Dougherty, is every unauthorized entry to another's land constitutes trespass if there is intent to enter the land of someone else, and actual damages is not a required element, and interference with quiet, undisturbed, peaceful enjoyment of the land is the damage. And lastly, this is the same thing, but it came from Rogers. Every unauthorized entry into land, but from Rogers we learned that this is also occurring when you overstay your welcome, so a privileged entry onto land. However, the defendant overstayed their welcome. I already read trespass to chattel. Let's read it again. The defendant intentionally dispossessed another of chattel, or using or intermingling with a chattel in the possession of another, and interfering with the possessor's business, which we have in the case called CompuServe. In the CompuServe case, a guy was sending out a bunch of spam to the customers that were using CompuServe as an internet service provider, and trespass to chattel was fit because they were considering the spam to interfere with like the data space and capacity. So I think we read conversion already, theory of conversion. By the way, chattel is personal property that is not affixed to the land. I believe we read all about trespass to chattels. We cannot do it any longer. That's ad nauseum. we've got a lot of defenses to read right now. What is it? Defenses have some elements of negligence. Intentional infliction of emotional distress is when the defendant acts intentionally or recklessly, and the defendant's conduct is extreme and outrageous, and the conduct must be the cause of severe emotional distress experienced by the plaintiff. And this was shown in Slocum and Taylor. In Slocum, we got a definition of conduct is so outrageous, a reasonable person would be caused severe emotional distress. Mere emotional distress is insufficient. And in Taylor, for a third party, intentional infliction of emotional distress, the defendant must have intended to cause the emotional distress in the third party, and the defendant knew that severe emotional distress was substantially certain to be produced by their conduct. So if you beat up somebody's dad in front of them and they experience emotional distress, you probably didn't cause enough emotional distress. But let's say you stabbed somebody in front of their daughter, and you knew that the daughter saw it, and you knew that it was likely to scar her, then you would be found, or at least we would find that to be sufficient evidence to have a case on emotional, intentional infliction of emotional distress. So, battery is the last duplicate note card that I have here, but it's from the Restatement of Torts. The actor is subject to liability to another for battery if he acts intending to cause a harmful or offensive contact with the person of another or a third person, and harmful contact with the person of another directly or indirectly results. Let's go into, before we completely close the book on intentional torts, let's just talk about willful, wanton, and reckless conduct, which is a deliberate disregard, a conscious disregard for a known high degree of probability of harm to another. That's what willful, wanton, and reckless can be amounted to in tort law. There are defenses that are relevant here. Governmental immunity. Under the doctrine of sovereign immunity, governmental units, such as state, municipalities, government contractors, and public officials, were traditionally not subject to tort actions unless they had consented to the suit. So occasionally, under the Federal Torts Claim Act, you have the federal government waiving its immunity, and there are several statutes to this effect at the state level also. Your defenses to, say, for instance, false imprisonment would be your shopkeeper's privilege, that the shopkeeper may detain shoplifters for investigation. 1, there must be a reasonable belief as to the fact of theft. 2, the detention must be conducted in a reasonable manner, and only non-deadly force can be used. And 3rd, the detention must to be only for a reasonable period of time and only for the purpose of making an investigation. So in order for a shopkeeper to detain a shoplifter for investigation of shoplifting, there must be a reasonable belief behind it as to the fact of theft, and the detention must be conducted in a reasonable manner. No deadly force can be used, and it can't be for an unreasonable period of time, only enough time to conduct the investigation. There's immunity, which we discuss in government immunity, but immunity avoids liability and tort under all circumstances within the limits of the immunity itself. And for the examples that we have here is absolute privity for judicial, executive, legislative reasons to publish defamation. And so that immunity is a type called litigation immunity that protects the attorneys and the judge when they write up their case summaries. Litigation immunity protects the attorney from tort liability for questions asked during a deposition alleged by the plaintiff to constitute intentional infliction of emotional distress afforded to judges, witnesses, court-appointed guardians ad litem, and court-appointed psychiatrists. Another defense is privilege. So, defendant avoids liability for tort conduct only under particular circumstances, and because those circumstances make it just and reasonable that the liability should not be imposed. And when we discuss liability, we discuss nominal, compensatory, and punitive damages. Nominal damages are awarded to vindicate the rights of the plaintiff, which may be in amounts such as $1, just in order to, say, hold them accountable, charge them with a tort, like a battery or trespass. Compensatory damages restores the plaintiff to the pre-injury status insofar as possible, and punitive damages, which is on top of compensatory damages. You can never have punitive damages without compensatory damages. These are afforded to the plaintiff to punish the defendant and to deter others from doing similar conduct. That's all the defenses I have written in my note cards right now. There are more. Expect them in my next recording. There's a collateral source rule that kind of comes out of nowhere, and that's unless relevant for another reason, the benefits from a collateral source is like an insurance payout is not relevant for the mitigation of damages. For example, to be considered by a jury in the calculation of damages, the jury shouldn't know how much that person has recovered from the insurance company. What the jury has to determine is how much the plaintiff should be awarded for damages based on the plaintiff's responsibility. Joint and several liability. Each of several tortfeasors is liable jointly with the others for the amount of the judgment against them, and that each is also individually liable for the full amount. So that was a law that was established in England and brought to America, and joint and several liability tends to not be the case so much anymore. We are now breaking down into comparative liability, the extent. So in other words, if a fire came from the north and a fire came from the south, and they both reached the plaintiff's property at the same time and caused damage, if you knew who started the fire in the north, you could recover all of your damages from him, even though the fire from the south also was partly responsible for your damages. But that only is the case if you read this rule very specifically. That the full damage could have been experienced by the plaintiff by either one of the fires. It's a really bad example. So I'll just read this one more time. Each of several tortfeasors is liable jointly with the others for the amount of the judgment against them. Meaning, if you know the identity of the south fire and the north fire, you can recover, half and half. Half from one and half from the other. But each is also individually liable for the full amount. If his act was enough to have caused all of that damage. So the joint and several liability only occurs if, the damage is attributable to them both. The plaintiff may recover from any one of them or both. The defendant can't make the plaintiff enjoin nor prevent the plaintiff from dismissing a co-defendant without filing a cross-claim against the co-defendant. Moving on to the landlord rule. Landlord owes a duty to exercise ordinary care in maintaining and maintenance of the premises, to duty to take reasonable precautions against criminal acts based on special relationship, like an innkeeper or would owe that type of a duty to a guest. So A, the ability to exercise control, and B, the landlord is in an advantageous position in exercising control and minimizing risk. This is the rationale, that is. And C, knowledge of the landlord about the risk of criminal behavior. So this obviously came from a case where a defendant should have had, say, cameras or protection for his tenant, and by not having it when he knew the tenant or the property was in a location where the tenants had been robbed, was a breach of his duty to his tenants, especially if he had protection from a security guard at the time the tenant moved in, such that they thought they would continue receiving that protection, and then it wasn't at the same level at the time of the attack. So That's just an example of the landlord rule. There's a lot more rules that we're going to discuss in another recording when I have them all written down. So back to negligence. No, before going back to negligence, there's a maximum recovery rule, and this comes from Anderson and Richardson. Richardson referred to this as damages that shock the conscience. A judge may adjust damages if the jury is unfair.